Hello, everybody. I'm Monica Thomas. I'm the Director of Social Work here at Goodwin House, Alexandria. Thank you all for joining us. We are back by popular demand is the End of Life series. Okay, that was my attempt at a joke. Anyway, but it is. It was last year when I did this, people said we should do this every year, so we are doing it every year. And our very first speaker is Kim Fisk, who is an elder law attorney, also has just served about 12 years on our foundation board and has now moved, thank her very much, to the Goodwin Living Board. So we are very honored to have her here, and I'll just let her take it away. Thank you so much.
Okay, thank you. Can you hear me? Thanks. Thanks, Monica. It's great to be here again. I love this intimate group. This is wonderful. So just some housekeeping. If you've got a question, raise your hand. Let's just talk it. Let's do it right away. Don't wait to the end, okay? Let's see, I guess that's it. That's the only housekeeping. So we're going to talk about estate settlement, the exciting topic, estate settlement. And so the first question is, what's your estate? What does that mean? What you got? Exactly, and that includes everything. Includes everything, bank accounts, investment accounts, real estate, retirement accounts, clothing and jewelry. That's always a big issue that could lead to fighting among your beneficiaries, and digital assets, your accounts that are online. And I think it's really great to pay attention to that. I think nothing is more eerie or sad when you start getting notices on Facebook from someone who's gone. I've got one of my friends that I keep getting, Budil is following X, and Budil's been gone 5 years, and I want to tell her relative how to take that down. And so that's all part of estate settlement, those kind of things. And so the really broad explanation of what estate settlement is gathering your assets and your debts, paying all the debts off, and then distributing what's left to the beneficiaries. Just simple as that. But I've got about 40 more slides to talk about the details. But that's essentially what we're talking about. And there's different ways to do it, and it's based on the different types of accounts and assets that you have. So when someone passes away, one of the very first things to do is secure their personal property. And that includes changing the lock. A woman came to me just this week, and she lives in Green Spring, and she said she had filled out the forms for who could have entry to her apartment upon her death, and she gave 6 people. And I'm the executor. I said, oh no, we're not having 6 people coming in your apartment, because by the time I get in there, everything will be gone, or at least the good stuff will be gone. So if you're in charge of someone's estate, you really have to take control of all the assets, change the locks, and if there's something really valuable, remove it from the residence. Now that may not apply here, but I think that, question? No, but I think that you can restrict access to the apartment if someone passes away. I've done that before. And that's important because the person who's settling the estate is in charge of the property, and they're in charge of making sure that the property gets to the right person. Jewelry is something that often walks away if people are in the apartment that aren't authorized, because that's sort of easy to take, and you can't really track where it went, and so you just don't want to be in that situation. Just secure the property. Yes, sir.
Goodwin House has a certified letter regarding that particular issue.
Oh,
Who can get in and who can't.
exactly. And I think that's what the woman in Green Spring was showing me, and she had 6 of those, and she was allowing 6 people in, and I said, no, you can't do that. This is a great thing right there to help prevent a problem of property walking away. So thanks for letting us know. Yes, ma'am.
When we're talking about securing the property here, in general, Goodwin House administration, such as maintenance and housekeeping, have access to our apartments for particular reasons. It's like we get housekeeping comes in once a week on a routine basis. Maintenance, if we ask for it, comes in, and if we give permission, they come in without us being there. So are you recommending that if there is a death, that we stop those services temporarily?
We actually
No. Oh,
We actually stop those services.
Oh, okay.
Yeah, we do. I mean, if everyone in the apartment has passed away, then we limit the access to the people, the executor. Yeah.
And I don't really think that those are the people that we're concerned about, right? Because they've been in and out of your apartment all along. It's more like the relatives that have come from Illinois, and they're like, oh, I always liked that ring, and maybe I'll just go in the, drawer and see if I can find it. And so initially, I tell people to, oh, I'm sorry.
Yeah, when you're talking about settling the estate, is that the same person as the executor of the will?
The executor, yes.
The executor.
I'm going to
Did I
talk.
say executor.
Similar function.
All right.
Yes, I'm talking about the executor or the trustee, and we'll get into those details in a minute. I guess right now I'm kind of generally speaking, whoever's in charge. Securing the residence, focus on the funeral or memorial service, and I have this handout. Monica told me that there's one of these handouts for Bailey's Crossroad, Alexandria, sorry. This one I just happen to have is Bailey's Crossroad, and it's from Alex Allen, the chaplain, and it has just like something that you could fill in that says what type of service that you'd like to have, and then it has like other questions to consider, like do you want a sermon, do you want a burial service, do you want things on display? So if you wanted to, you could fill this out in advance.
Yeah, Bruce does have, our chaplain has that, and we'll be happy to meet with anyone who wants to discuss those sorts of things in advance. He keeps files on everyone and is prepared at the time. So
Bruce has been really helpful to me when I've had to do services. His services are great. One of our services, he taught us a dance that was so great. It was Miss Coughlin, because she liked to dance. That was really great. And then he also has pictures and like information from their interview. He does really a great job. So when the death certificates become available, that's when you can begin working on financially related matters. And death certificates usually take 5 to 10 days after death to be available in Virginia. Question? Yes.
Sorry. I had someone in the family who was settling someone else's estate asked me this question. And I gave them an answer, but I'm not sure it was anywhere close to correct. They said, how many copies of a death certificate should you get?
Such a good question.
And I said 20.
20's good. 20's good. I usually say like 10 to 20. If you don't really know anything about the estate you're about to settle, I think it's good to have more than fewer. They cost $12, so it's not that expensive. And if it turns out you don't have enough, you can order more. You can order them through the funeral home, or Vital Statistics in Virginia is where you can get them. It might take a week to get them, but 20 is a good number. And it does depend on how many accounts you have, but at this point you don't know. So that's a good rule of thumb. So one of the first things you need to do is figure out what kind of estate document does the person who just passed away have. So maybe the person has provided you with a copy, or you might have to do some searching. And so go looking for a will or a trust. And then it's important to take a look at, you find something, is it signed? Are you looking at an original, or is this a copy? So again, the woman who came in this week, she gave me what she said was the will, but it was a copy. I could tell it was a copy. And other times people have brought me a will, and I can see it's a draft. It's not even signed. So sometimes people keep these old documents in their file, and it's a little bit hard to figure out what's the real one, what's not. So you're looking for something that's signed, and once you determine that you've got an original document, who's named as the executor? Who's the trustee? It'll say right in the document. And oftentimes the document states who drafted it. In Virginia, a will has to state the name of the drafter, and so you can always call the attorney and say, ask any questions. Is there additional information you know about this person who has passed away? Do you have originals? What do you have in your file that could help me? Like for me, when I meet with clients, I have a list of their assets, and I have information about their family, and so that could be helpful to someone who's trying to get started on settling the estate. When you're going through the legal documents, you might find something that says power of attorney at the top or advanced medical directive. And those are documents where the person who passed away named someone as their agent to act on their behalf, but those cease upon death. They all cease upon death because the idea is you're their agent, so they have to be living for you to act as their agent. So if you are named as an agent, don't write checks after they die. That's not good. You're not supposed to do that because your power ceases at their death. A lot of people don't know that. So, yes, sir.
What if it says durable?
Durable is until the death of the person who signed it. And it also means if they become incapacitated, it continues. So it doesn't continue after their death. It just continues if they're incapacitated and up until their death. Sure. That your power as an agent ceases when the person who you're the agent for dies. We call that the principal. So if you're an agent for someone, you can no longer sign checks when they're gone. So then we move into estate settlement, and we have either the executor or the trustee. They're the ones who now become the person who stands in the shoes of the person who died. So if they're the same person, that is fine, but they're serving in a different role now. So they still cannot, even though they might be the executor, they still cannot sign checks as agent. Yeah, a lot of people don't know that. Even attorneys, I've seen attorneys continue to sign, but you're not supposed to.
There's a gap. Your power of attorney ends on the date of death,
Yes.
but until you're appointed executor, you can't do anything as executor.
That's true. That's exactly true. There is a gap.
Can you explain appointed by?
We're going to get into that.
That's great.
So I'm going to use an example. This is Taylor. Her mother, Dorothy, died earlier this month, and we're going to go through the whole process with Taylor. So we said to Taylor, please gather statements, life insurance policies, tax returns, anything that looks official or legal or related to money. Just gather it all up and stick it in a bag and bring it to our office. Look in the desk, the office, the recent mail. Tax returns have a lot of good information because there's a schedule that states where you got interest, and so that helps determine where you might have accounts. And so this is what you would do, just gather everything. And people come in with roller bags full of stuff that they've gathered. And we put it all on the table, our conference room table, and we start making piles. Because each asset is distributed according to how it's owned. So we make a pile for the debts, all on one side. Accounts that are jointly owned go in one pile. Accounts with beneficiary forms go in another pile. Accounts in the name of a trust and accounts in individual names, all those go in different piles because they're all handled differently. So sometimes we have to do some research. This is a sleuthing part. And that's because we might have an old statement that you gathered up, and we don't know if the account was closed or not. There could be a letter from a financial institution that says, just want to let you know, we've changed our office. But that indicates that the person who died had an account at this financial institution. So we want to just make sure that we don't forget anything, things that look important. And in my office, what we do is write a letter to the organization and say, your account holder has died. Here's a copy of the death certificate. Please let us know if there's still an account at your organization. Debts. So we've got a whole pile of debts, and we're going to look at the different type of debts. We're going to make a list. I guess the biggest thing I would say to you is don't pay credit cards right away. Credit cards are unsecured debt, and they're the ones most afraid of not getting paid. And so they're going to start calling you. They're going to start calling the family members of the deceased, and they're going to say things like, don't you want to honor your relative by paying their bill today? Don't do that. Then they might say something, well, the credit will be ruined. Well, the person's gone. It doesn't matter. It doesn't matter. But I know clients, family members that say, oh my gosh, I want to honor my relative and pay the debts right away, right away. Not a good idea, because we don't know the situation in the estate. It could be that someone has an insolvent estate. And if a person has an insolvent estate, there's a certain order in which you have to pay the debts. And just like the credit card holders know, they're last. And they may not get paid if the people above them in order are paid first. And you would say, gosh, if I'm settling, did I just do that? If I'm settling an estate, then I would know if the person had an insolvent estate or not. Not necessarily. I was an executor of someone who I had known for a long time, and she had come in, we'd known each other for a while, and she had a nice account and a nice retirement account. But it turned out that she got into gambling at the end of her life. And her estate was very small, and it did not cover all her debts. And so that was a problem. And so you just don't know. You know, I didn't think that. I was really surprised. Her daughter was really surprised. So you don't know. So you need to be really careful and just not pay those credit cards, even though you feel like you want to.
What about the interest on the credit cards?
It ceases upon death. It does. And furthermore, you can have any late payments deducted too. Yeah. So now we're going to look at those. Oh, yes, ma'am.
Some of them are paid automatically out of my credit card. I mean, it's just it's automatically taken out. What happens with that? Because people who are left may not realize that.
That's a really good question. The question is, what if your credit card payment is automatically taken out of your checking account? I guess when you're going through all the different accounts and you find a checking, what I do, when I find a checking account, I look and see what bills are coming out of the checking account. And I can notify the bank that you've passed away, and they often stop debits and credits coming and going in the account. So that could put an end to the automatic payments. On the other hand, if you have someone that has a mortgage, they have a house, they have a mortgage, and you see on the credit card, or you see on the statement that mortgage payments are coming out, sometimes I don't let the bank know till maybe the next month when I understand how things are going, so that that payment does come out. So you can manage it both ways. But for credit cards, you could let the bank know and they'll stop it. So
I have a follow-up question. What happens if you don't, like, let's say it's there's not a clear, I'm just curious, if there's not a clear who is the executor and someone does own a house with a mortgage on it, how does that work in terms of if it takes a while for probate to happen and, just curious. Like if you stop the payment, but the house still has a mortgage, how does that work? I'm sorry, it doesn't really apply to people here though, but it might apply to someone who has a house.
So you would let the mortgage holder know that the owner has passed away, and sometimes they allow a grace period of a couple of months for you to get your assets figured out, but eventually they're going to want payment. And if there is no payment, then they will foreclose. So you need, in those situations, it's good to make sure that it continues. If there's a clear beneficiary and the payments have stopped because there's not enough money in the account, then sometimes I tell the beneficiary, just make those payments till we sort it out. Because they're going to get the house eventually, and we're going to sort everything out. But rather, to keep it out of, foreclosure. Thanks. Yeah. Okay, so it's all about ownership. And so property passes 4 ways upon death. And they are by operation of law, that would be a joint ownership. By contract, and that would be the pile that has the beneficiaries. By trust or by will. And so we'll start with the operation of law. And these are joint accounts. This would be an account that you own with someone else. There's 2 kinds of joint ownership, with survivorship or without. And this could be real estate or bank accounts or investment accounts. And so joint tenant with right of survivorship means that when one owner dies, this other owner gets the whole account. All you do is go to the bank or the investment advisor and show them the death certificate, and they just take the name of the person who died off the account, and it becomes the other owner's account. The other type is joint tenants without survivorship. One owner dies, and the account is divided between the owners, and the ownership, the person who died, their share of the account goes according to what their will says. And this is really important. A lot of people say, oh, banks automatically set up their accounts with right of survivorship. Well, I had a man who died, and he told me before he died, my $5 million account with my son is joint with right of survivorship at Bank A. It's a brokerage account, and I know it. He died. It was not. It was joint tenants without survivorship. And so one half went to his son, and the other half of his account went through his estate. And it was in his individual name. It had to go through probate. We were not happy because there were probate taxes on one half of the $5 million account. So it's a really good idea to check and not just think that you know. Look at the account cards or paperwork that you sign when you open the account. And be mindful when you open future accounts. I also want to let you know that no matter what your trust says or your will says, if your account is joint with right of survivorship, then that account is going to pass to the joint owner. So let's say you have a will or a trust that says everything to my daughter, but then you have this account that's joint with right of survivorship with Monica. Monica will go down to the bank with your death certificate, and the money's going to go to Monica. They don't even look at your will or your trust because it passes by right of law. So beneficiary forms. If you've got a life insurance, a retirement account, annuities, or an account that has a payable on death beneficiary, the same thing. You just go down to the bank and give them the death certificate, and they'll write a check for the person whose name is a beneficiary. I'm looking for my story. For things like life insurance or retirement accounts or annuities, you may know that there's a beneficiary, but you may not know who the beneficiary is. And those account holders aren't going to talk to you because you're the wife or the brother or the sister or the executor or the trustee. They're only going to talk to the person who's the beneficiary. So you can notify them of the death and give them the death certificate, and they say, thanks a bunch. We're going to notify the people who are named as a beneficiary, and we're going to send them a claim package. And if you don't get a claim package, you're not the beneficiary. And they won't tell you. Like if you call up and say, what's happening? We can't speak to you. We can only speak to the beneficiary. I don't know if anyone has encountered that before. No? People get really mad. They say, but I'm the wife. Yes, you have? Yes. Yeah. And sometimes you have to do a guessing game. It's like, okay, could this be the niece? And we don't know the address. And could we just like call them and say, are you looking for Susan's address? And yep. But I understand it. But just to let you know, that might happen. Just said that. It's really important for you to check your beneficiary forms now while you're living. This is just a little note, a cautionary tale. Don't forget to remove an ex-spouse as a beneficiary. In Virginia, Virginia helps you out. If you are divorced after 1972, in Virginia, automatically, if your spouse is named as a beneficiary after 1972 or after your divorce, then they can't take. And that's a great Virginia law. But it's not in all the states. And there's a real famous case where a man with a thrift savings plan from his work in the federal government forgot to change his beneficiary, and he named his ex-wife. Well, he lived in Virginia, and his current wife said, no problem, I know the Virginia law. No, DC law prevailed. The ex-wife got the account. So after that, all the estate planners and CPAs are, oh no, no, no. So we always say, please check your beneficiary forms and just, don't think that you know, look at them and be sure that you know who you've named, especially on those big accounts. So let's talk about assets that are titled in the name of a trust, a revocable living trust. Those pass to the beneficiaries listed in the trust. We've got some people here I know who have trusts, which is great. So what is a trust? Does anyone know what a trust is, or does anyone have a trust? Oh gosh, a lot of people. Oh great, okay, all right, super. So this will be a review for you, but then so maybe we have some questions, and please don't hesitate. So it's a legally enforceable declaration of how you want to leave your assets upon your death. It's effective during your lifetime. During your lifetime, you're the beneficiary. And then when you die, your trust continues on, but your beneficiaries change. It continues after your death. It has a separate name. So when Dorothy's daughter Taylor came in, her mom had a trust. It was the Dorothy Trust. And Dorothy was the trustee. So she retitled her assets from her individual name to the name of her trust. She was a trustee and she was a beneficiary. She named Taylor, her daughter, as successor trustee. So Taylor takes over as trustee, and trustee is manager of the funds that are in the trust. So now Taylor is going to manage these funds according to what the trust says. So in the trust, Dorothy had an investment account and a condo. Taylor has immediate access to assets in Dorothy's investment account and condo because she's the manager. She just needs to go to the account holder, show the death certificate, and say, Dorothy's passed away. The investment holder, the account holder, will look at the trust and say, oh, yep, she passed away. Oh, I see, you're the successor trustee. Now you have control, like that day. And so when you ask about the gap between being a power of attorney and being an executor, there's no gap when it's a trust because the trustee doesn't have to be appointed by anybody. It's in the document. And so all that is required is a death certificate. And now the investment advisor can take instruction from the daughter, from Taylor. So no gap. It's really convenient. And so Taylor can say, okay, investment advisor, I've got some bills here over here in this pile that I need to pay. I want to take some money out of the trust to open a checking account in the name of the trust. Or if there already was a checking account, she could access that, but assuming there's not. So she can take money out of that trust, go open a checking account in the name of the trust, and start writing bills and paying off Dorothy's bills. She can pay those credit card bills if she sees that there's enough liquidity. She needs to get a tax ID number, but that's just a small thing. So those assets pass directly to the beneficiaries. After Taylor pays all the debts, she can just now write a check to the beneficiaries. There's no probate, there's no court supervision, no probate fees, no public record, timely transfer of assets. Taylor's responsibility is to make sure all the debts are paid, and that includes taxes. So if she was prudent, which she would be, she would hold some money back to pay taxes. So let's say we said her mother died in April. There won't be the taxes will be due next April, so she should hold some money back. But other than that, she can distribute everything else out to the beneficiaries right away. A will is not the same. Yes, questions, yes.
In the state of Virginia, if Taylor is out of state as the executor or trustee, does she have to have a representative in Virginia to perform her duties?
We're talking about trustee right now. Right now, she does not. She does not need to have a representative. We'll talk about executor when we get there, okay? Uh-huh.
I just want to clarify the difference and the why between writing a check on the deceased's account and opening a trust checking account. I guess I don't understand why why you would need to open a new account.
So if Dorothy had a checking account that was titled in the name of her trust, then her daughter Taylor could use that and act as the trustee. If the account was titled in Dorothy's individual name, the trustee does not have access to that, doesn't have rights to assets titled in individual name. If it's a joint account, then it's going to go to the joint owner. And so then the joint owner can write checks, okay? It's that titling is so important. It really is. You have to like keep on going back. How's it titled? How's it titled? Who has control? I think this person, then we'll get you. No, I think of the woman in the blue jacket.
I just wondered about the cost involved in getting a trust set up.
So it varies, and it depends on, it varies. So I would say that it runs somewhere between $3,500 and $5,000 to set it up. And so the question is, do the fees continue for the life of the trust? Not to the attorney, because the attorney is setting it up. It's a one-time thing. You sign the trust, and off you go. So the attorney doesn't have any additional fees at that time. Now, you might have fees that you would have anyway if you have an investment advisor or something like that. But for legal fees, no. Some attorneys might have that situation, but usually there is not. I serve as trustee for some people, and I don't charge like a regular annual fee or anything because I'm not doing anything. And that is a situation where the person who drafted the trust is their own trustee. No, the person who established the trust is their own trustee. So like if you came to me or another attorney and said, I want a trust, we draft the trust, you're the trustee, you sign, and off you go, and our relationship is over. You're not, I still see that question on your face. Yes?
What are the costs for probate? What's the big deal about not going to probate?
So the probate has fees. There's a tax on all of the assets that are in individual name. We'll talk about that next. We're getting there, but I can answer it. And the probate cost, just the tax, is 10 cents on every $1,000. But then after that tax, there are reports and different things that you have to file. And every filing has a fee. So you first file the inventory. It's filing in the probate court. And so the first filing is an inventory where the executor lists what is in the account, right? And so there's a fee for the inventory, and it's based on the size of the estate. And then after that, the executor has to account for all of the assets that are listed on the inventory, account for their actions, how they handle the money, and there's a fee for that accounting. And that's, again, based on the size. So the fee could be anywhere from $800 to $3,500. And there's 2 or 3 of those filings. So that's kind of where the expenses add up. And it's also that it takes a longer time because you can't distribute the assets until you go through the different process. So that's another negative. And we're going to learn all about it.
Is that the same for like if there's a house in the trust, they would have to, for probate, if it went through probate, they'd have to pay the same fees?
Yes.
Significant, okay.
It is significant. So let's say you have $1 million house, that's $1,000 right there, just in the probate tax.
I have another question. Many people name their spouse to be the successor trustee. Can you talk about the wisdom or lack of wisdom of naming more than one person to be your successor trustee? Meaning like, if you have your spouse, should you also name a child because of the likelihood that they might pass away?
So naming fiduciaries, and this would be trustee as well as executor, I think it's really important to name someone who is able to do the job. It's not honorary. There's actual work that needs to be done. And you should name one person, and you should name an alternate, just in case that one person isn't there. And that one person could be sick. The first person you name could be sick. They could die before you do. Or they could be, like during COVID, we had someone who was named as executor, but was in Hawaii, and they couldn't get back. They couldn't because of their health, they couldn't fly back. And so anyway, so that was a really unusual situation. So you should always name an alternate. And I think, Monica, you're asking also, should you have two serve together? Right? So you can name one, or you could say, I want co working together. And again, it sort of depends on the people that you're choosing. Like sometimes someone will name a spouse, but they're saying, well, my spouse is a little bit older, maybe I should have a helper. And so therefore I'll name a child too. And so sometimes people do that. And that would make sense. The spouse is still involved, but maybe the child is going to do the paperwork. And that shows respect and dignity to your spouse. Some people say, oh, I can't even name my spouse at all. That's not going to work. I'm going to name a child. And then they start saying, well, I have 4 children. Why don't I name all 4? Nightmare. Nightmare. Don't do that. I mean, if you've got 3, okay, but I don't think that's a good idea because there's certain tasks and they all have to agree. And, it's not great when the executors are fighting between themselves or among themselves and you can't get anything done. Question?
If you already have a trust and it's well established and for years, and then you need to make a change in the trust, do you have to have the trust completely changed and repay that amount of money, or may you change it within the trust itself?
So you can do an amendment to your trust, and the amendment could be a complete amendment or it can be a partial amendment. It depends on what needs to be done. So if you're just going to change the trustee, then you can just do an amendment to that, which would be partial.
Which you can do by yourself, or do you need a...
No. If you do it by yourself, I think that you would have a lawsuit when you died, and that would be really expensive. So I think that you should see an attorney to draft it properly so that there's no ambiguities. Oftentimes people that draft it themselves, they don't understand that there's a conflict that they may have had in the language, or the new document might conflict with the old document, and a judge has to determine which one rules. And so I strongly recommend seeing an attorney, and they'll charge on an hourly basis, and it might take 2 hours to do something like that. My husband is a litigator. He loves a situation where people draft their own. It's great for his business. I don't like it, but it's happened. We had one case like that the person died here, but there was a beneficiary in Wyoming, and there were different rulings. We won, we lost, we won, we lost. It went to the Supreme Court of Wyoming. Can you believe that? It was so expensive. It was so expensive. Yeah.
If someone has power of attorney over your checking account, can they continue to write checks after you've passed?
No, they cannot continue to write checks after you pass if it's power of attorney. If they're joint, that's different. But if it's power of attorney, it ceases when you die. Okay, so I'm going to move on to talk about a will. We talked about trust and how assets pass when you have a trust and how the trustee takes over. But what about those accounts, those assets that are in your individual name? So in Dorothy's case, she had a whole lot of money in her trust, but she had this one checking account. It was in her individual name, and it had more than $75,000 in it. So Taylor said, I'm not really sure what the situation is with this account. I'm just going to go to the bank and give them a death certificate and see what happens. And one of 2 things could happen. There could be a payable on death beneficiary named, or the account needs to go through probate. So if she goes and gives them a death certificate, they say, oh, hold on just a minute. When Dorothy established it, she named a beneficiary. Let me look at the beneficiary form. Oh, Taylor, you're the beneficiary. Great, here's a check for you. Or they might say, it is an individual account. There is no beneficiary named. And the only way to get that account transferred to the beneficiaries is it has to go through probate. So what is probate? We talked a little bit about that. It's the court ensuring that your wishes are carried out, and the court oversees the activity of your executor. The court ensures that the will is valid, and they also make sure your debts are paid and your assets are transferred to the named beneficiaries. So the court provides an important function. It's a good thing to have, but it's expensive. In some situations, maybe you want your executor overseen. So in this case, Taylor is named as executor in Dorothy's will. Just because you're named executor doesn't mean you're automatically executor. You have to be appointed by the court You have to make an appointment with the probate office and go bring the original will, the death certificate, and all this sort of, and the estimated value of Dorothy's asset, which we now know is that account over $75,000. And the probate court will appoint the person named as executor. You get a certificate of qualification from the probate office, the probate clerk, and that's the authority for the executor to now go back and talk to the bank or other places where there's individual accounts and to gather those assets. The accounts can't stay in the name of the deceased person's name. Those accounts have to be closed, and a new account has to be opened in the name of the estate of, in this case, Dorothy. Since Dorothy is gone, you just can't keep everything in her name. It has to end. And you need a new tax ID number.
Is there a time limit on that, like we were talking about earlier with the credit card payments and everything? Is there a time that it has to be switched over?
There is not in Virginia. No, there is not a time. That's right. Not all assets have to go through probate. Only assets in individual name greater than $75,000. There's an abbreviated probate for assets under $75,000, and that is a small estate affidavit, and it's a certain procedure where you prepare this affidavit, you sign it, you wait 60 days, and then present it to the account holder. And whether or not they'll comply is another thing. Right now, I have one before PNC, and their legal department has denied my request twice. They're not following Virginia law, and it's making me really angry. But they're asking me to go to probate, and the account's $2,000. In Virginia, the law says you don't have to go to probate unless it's $75,000 or more. So I gave you more information than your question. Anyway, so then now we've got accounts in the name of estate of Dorothy. When Dorothy's named executor, she has some tasks that she has to do. She's got to notify Dorothy's heirs that she was appointed. She has to file an inventory with the probate office stating how much money is in the estate. She has to list all the accounts over which she has control. Later on, she'll file an accounting stating how she managed those monies. And the accounting will be, I paid probate taxes, and I paid my attorney, and I paid, if there's a building, if there's a house involved, I paid electric bills, and I paid insurance for this. Or if there's a car involved, maybe another expense would be gasoline or something for the car, a repair. So those are the kind of things that show up in the accounting, and it could be, some of our accountings are like this big, and some are small. It just depends on what the estate has. Once all of the accountings are, filed and approved, then the assets can be distributed. It can take a while. Like the accountings aren't due until 16 months after death. That's a long time. So the probate process can take at least 1 year, 2 longer. We talked about the expenses. That inventory of your assets is a public record. Anybody can go and get a copy of what you owned when you died. A lot of people in this area want privacy. And so if you have a trust, there is no record, there is no filing of any sort. So a lot of people just enjoy that privacy. And one of the reasons they might prefer a trust is for that. If Dorothy did not have a will, but we still found that account over $75,000, she still has to go, the daughter Taylor still has to go to through probate, but now the Virginia laws determine who the beneficiaries are. So in the will, Dorothy could say, I want my beneficiary to be Goodwin House and the Dog Rescue League and 1/2 to my daughter. But if she didn't have a will, then it's what Virginia law says is the beneficiaries. And Virginia law would say my spouse, children, there's just a hierarchy of who the beneficiaries are. Does anybody have any questions about that? Okay. And so when Dorothy dies, what other tasks does Taylor have? Make funeral arrangements. We talked a little bit about that. Provide information for Dorothy's death certificate. This is a big deal because they're going to ask the names of Dorothy's parents. I've served as executor for clients that are older, and they ask me my clients' parents' names. I don't have any idea. So it's really good to write these things down. So when information is needed, you've got it handy. And there's a couple of places to do that. There's these great books. Here's this book that says, "I'm dead, now what?" And inside it, there's just lists that you could, provide information for someone so that they can do things accurately and without having to sleuth through things. And so there's categories like medical, who are your doctors, key contacts, my dependents, important documents, business, my pets, my insurance. A woman came in last week and she said, my sister died recently, but before she died, the neighbor's tree fell on her shed. I said, oh, wow, that's very interesting. Do you know the insurance on your sister's house? She said, I don't know who insures my sister's house. So we're scrambling to figure that out. Meanwhile, we're writing to the neighbor. But in Virginia, I think that she has to pay for it. But we don't have information about the insurance on the house. So that's been a little bit of a problem. So there's this book. And then there's another book which is similar. It's called Memory Bank. And it's kind of the same thing, where there's different information and it just prompts you to record things that would be important later. Things about your vehicle, healthcare, bank and investment accounts, but names of your parents, really important. Back to what else Taylor's going to do. She's going to pull a credit report to see if there's any other accounts or debts that we're unaware of. She can check unclaimed property websites to see if there's money that was due to her mother that hadn't been collected yet. We see a lot of that. She needs to file the tax return for the year in which her mother died, so that would be 2026. And she has to dispose of Dorothy's personal property. So as I said, don't make your executor or trustee hunt for information. Provide it through these books or just list. There's another handout that's really great. This is from the Aging of the Diocese of Virginia. It's called Are Your Affairs in Order? And I can provide a copy of this if you want. Monica has a copy of this. And it's the same kind of thing. It has blank lines, put different information. But one of the things I also like about it, it talks about, gives you some ideas for funeral. And it even goes so far as to recommend hymns and readings. So it's kind of nice. You can list your different citizenships, stuff like that. It's good to have that information. Monica's got it. Or I have a card, I can email it to you if you want to take my card. Do that. It's a lot of pages, 58, so I didn't bring copies. So things that you can do is just make it easier. Just make it easier for the person to settle your estate. Where the heck are your bank accounts? What credit cards do you have? And your insurance. Information for your death certificate. Passwords. Passwords are important. Don't put your passwords in your laptop. We can't get in it. Shred draft documents or old documents that are revoked so that people know it's easier to find what's the original. Sometimes people come in when I do their documents and they have this whole binder of old things, like 19 something or another and 2000. I just say, I'm going to take all those and shred them, just so it makes it easier. Also, what if you changed your mind and back in 1902 or 1922, 1992, you name one person, but now you've taken it out. There they can see that, oh, you remembered them, but now you haven't, and it's going to cause a little problem. Might cause a will contest. They might say, oh, your newer will, you didn't have the presence of mind, but here's an indication you wanted to give money to me. So just get rid of that. Get rid of it. And make information easily available, like the cards in your wallet, the healthcare cards, if you have your birth certificate, marriage license, divorce, those are important. Social Security card. And I'm leaving you, the last thing I'm going to tell you is the password to your phone. Tell someone the password to your phone, because that opens everything. It opens everything. And you know you've got that two-part authentication. So if someone doesn't know the password to, I don't know what, your bank account, they can get it with your phone by saying, you know, change password, and then you get a code, and now you can get into other things. So that's really, really important, the password to your phone. So thank you for your attention. I really appreciate it. And let me know, do you have any questions?
Go ahead.
What's the life of a trust? If the trustee has executed all the things that you said, how does that trust disappear, or does it live forever?
That's a really good question. How does a trust come to the end? So as I said, it continues beyond the life of the person who established it. And in the document, it states who gets the money. And so at some point, the successor trustee is going to distribute the money out. And if you have, so let's say you have children and grandchildren, and in your trust, you state when they get the payouts or when they get the distributions. For your children, you might say, upon my death, and so that money will be distributed. But if you've got young grandchildren, your document might say when they turn 30. And so the money will stay in the trust for the grandchildren, and then at 30 they get it, and it ends. And then your trust ends and terminates.
Are you then obligated as the executor, trustee of that trust, obligated to file income tax for that trust in those ensuing years if you drag it out?
Mm-hmm. Yes. So the question is about income tax. So I'm going to answer about income tax during your lifetime. If you're the trustee, you don't have to file a separate income tax return, because on your income tax return you can include interest that was earned during your lifetime or in the name of your trust. But once you're gone, then the new trustee has to have a separate tax ID number and file tax returns for every year that there's interest earned over $600 in the name of the trust.
But if the trust has an EIN of its own,
Does that go over past death?
So if the trust has an EIN of its own, then you could, if it was established during your lifetime, for some reason you got your own EIN, then you could use that same tax ID number, EIN, same thing.
to close out the trust to pay, yeah. Okay.
Yep.
Could you speak more broadly about you established the financial threshold in Virginia for probate, but I'm not clear on how that relates to assets that are in a trust. We've always been told that trusts are a means for avoiding probate. Could you elaborate on that?
Sure. It has to do with how the asset is titled. So if you establish a trust and then retitle your asset into the name of the trust, then that asset will not go through probate at all. So there's going to be no relationship to probate. Probate is only for assets titled in your individual name. So for me, for example, so let's say I've got a checking account in the name of Kim Fisk and an investment account in the name of Kim Fisk's trust. This trust has nothing to do with probate. It just passes according to what my trust says, and the trustee is just going to go ahead and follow the instructions in the trust, distribute it out, and everyone goes on their merry way. But this checking account in the name of Kim Fisk is different. It has to go through probate if it's greater than $75,000.
When we were making our revocable trust about 30 years ago, we were advised not to retitle checking accounts, the automobile, and some other small assets like that. Is that still the case in Virginia?
Yes, I would agree with that. A little minutia about the types of assets. So if you have a checking account that's small that you use to pay bills, like if a man's going to come and clean your gutters, or maybe you go to the grocery store, I feel that privacy is really important. And so I instruct my clients, don't change the title on that. You don't want to, I think, you don't want a check that says Kim Fisk's Trust, because it sends a signal to someone about your wealth, and that could cause problems. So for those type of accounts, if you keep the balance low, I don't see anything wrong with keeping it in your individual name. One thing you can do is name your trust as the payable on death beneficiary, so that you can name your trust as the payable on death beneficiary, so that during your lifetime, that account's in your name individually, but when you die, there's the payable on death beneficiary, and it says my trust. So it goes to your trust and not through probate. The car, well, the car is interesting because you have to deal with DMV. And I call that the wild, wild west. Because DMV they have rules and policies. The clerks don't follow them. Sometimes I bring the copy of their policy of how to do things, and they say, here's how we do it. So it's hard to name your car, to retitle your car in the name of your trust. For years, we were using a beneficiary form at DMV. And so you have your car titled, and then there's a beneficiary, which is your trust. And sometimes that will work. But often, the car is worth less than $75,000. So you can use a small estate affidavit to pass that to your beneficiaries without having to go through probate. Yes, ma'am.
So I put my grandson's name on the title of the car and was told by doing that it would not go to probate. He would just get it.
That's true. Will he be driving it during your lifetime? So he's not going to drive it. I think that's true. Hopefully you're not opening yourself up to any liability in case he has a car accident. But it will avoid probate by doing that, yep.
Can we go back to the little paragraph you said about under wills, the executor being appointed in that process? I've never heard that before. So could you just say it again, maybe, and elaborate on it?
Sure. So are you saying, are you referring to when I said that just because someone's named executor doesn't mean that they're automatically executor? Yes. Mm-hmm. So the power doesn't, in that situation, the power is not granted in the will document. The power to be an executor has to be granted by the court. So the person who's named executor takes the will to the probate clerk, and the probate clerk reviews the will. If it's valid, on. Then the probate clerk appoints that person with a court order and a certificate of qualification, which has a seal on it and the clerk's name. And that's how the executor has authority. So your executor can't just go to the bank and say, hey, look, I'm named in the will. Now give me the account. Can't do that. The bank's going to say, where is your order from the court?
So, a follow-on question. Follow-on question about an executor being out of state. And something about an in-state agent or something like that. Would you explain if there's a complication with the executor being out of state?
Okay, so if you name someone who's out of state to be your executor, they must get a bond. They must be bonded. If you name an executor who is in state, then in your will you can say, I waive bond. You might say the same thing, but if your executor is out of state, the probate clerk's going to say, that does not apply. If your executor lives out of state, then we're going to require a bond. And that's because if they get up into mischief, Virginia can't get them if they're in Wyoming or Indiana or Maryland. So the bond protects the beneficiaries and the creditors to the estate. So that's the first thing. So they have to get a bond, and that fee can be paid out of the estate. You also asked about a resident agent. And so an out-of-state executor also has to have someone who lives here in the Commonwealth of Virginia agree to accept service in case something happens. And that's what a registered agent does. So let's say there's something filed against the estate. That filing, because of where they live, they're out of state, it doesn't apply to them, but it would apply to someone who has said, I'm going to be your agent and send it to me, and then I am responsible to make sure that this out-of-state executor has to comply.
Well, that applies to a will, but what about a trust?
Doesn't matter. Your trustee can be out of state.
Right.
And there's no special bond or anything else that is necessary.
Right, thank you.
Out of the country gets tricky, but we won't go there.
I have a quick question. It said your slides reference the original will.
Yes.
Can you talk a little bit about that?
It's key to have the original will if you have to go through probate. If you don't have the original will, then you have to petition the court to accept a copy as if it were the original. And that can get tricky because you have to, in the petition, state your belief as to why the will is lost. And then the judge will review your petition and anybody who might counter it, and the judge will determine whether that copy can be accepted as an original or if it is possible that the reason you can't find the original is because it was revoked by the person who died. So that involves going to court, and the judge makes a decision on whether you can claim a copy as your original. Does that make sense to you?
And that could take a while too to get that court hearing.
Oh, yes. It can take a while.
Process. Okay.
Yeah, and someone may contest it, and then that extends it, right? And someone who would contest it is the person who's left out, right? Yeah.
And
More than one copy of your will.
No, there's one original. Just one original, right? And I recommend people put it in their safe deposit box because once you're gone, there's a law in Virginia that allows someone and the bank to go into your safe deposit box for a will search. So they can retrieve it. And you know that it's not there. You know that no one has done away with it after you're gone. Like yeah, I'm going to stop right there. Sometimes wills disappear. If someone finds it and they look at it and it's like, oh no, I'm not really included. But if there was no will, I'd get a bigger share. That will might disappear. Oh, I've seen it.
When you have a will and the will says it's all in the trust, then do you have to show the trust to anyone, or is it automatically invoked?
So what you're saying, I think what she's asking is, when people have a trust, they also have a will. And the will says anything that's in my individual name on purpose or accidentally, I want that to be distributed to my trust and distributed according to what my trust says.
Right.
Instead of in your will saying, oh, anything in my name goes to Joey and Susie and the dog kennel. And so the beneficiary is the trust, and there needs to be proof that it's established, but someone doesn't have to see the whole trust. They can see the signature page and the name of the trustees, but they don't have to see.
Who is that person?
The court. The court's going to want to be assured that the trust exists. And so if there's a will and there's some assets in individual name, like in this case, Dorothy had her checking account. And so that checking account had to go through probate. The executor has to prove that that trust exists. But that doesn't mean a whole copy needs to be shown. Pages of the trust can be shown to ensure that it exists.
To a probate judge.
So that would go to the probate or the commissioner of accounts. They work together.
it's complicated.
It is.
All right. Well, we have gotten to an hour. Any other further questions? All right. Well, if you just join me in applause, thanking Kim for her knowledge and for.
And thank you for these great questions. I really appreciate and your attention on such a dry subject. So thank you very much.